upon this information without seeking professional counsel. And specifically, what we recommend is that if you need help with things that we're going to be talking about in today's show, that you seek out a qualified attorney specializing in federal contract law. And if you don't know where to look for one, I'd like to recommend as a source our legal partner at Prince McCall Potroff LLC. I've both been a client of this firm myself, as well as a longstanding history in working with Stephen when he was the founder and the owner of the firm. Stephen, would you like to say a few words about the KMP team?
Yeah, you know what? I've even got my Potroff mug of coffee here with me today. So yeah, this is a law firm that I founded, dedicated exclusively to serving federal government contractors and subcontractors. At least when I was there, most of the clients are small businesses, but not all. I had clients that were billion-dollar multinational corporations as well. But it is that exclusive focus. It's what's called a boutique law firm that practices solely in one area. It has a real depth of knowledge in the government contracting field. Those of you who know me know that I stepped back from legal work about 3 or 4 years ago to focus on doing things like this and other interests of mine. But my former law partners, Shane McCall and Nicole Potroff, and their excellent and ever-growing team of government contract attorneys still are, always one of my top recommendations for anybody who's looking for legal help in government contracting. So please feel free to reach out to them if you want more information about the firm. You see where to find it there.
Yeah, and also, we'll bring back the slide with the contact information at the end. And I want to say when we do have the Q&A, we're not going to really be able to go down into depths about your unique specific situation, so kind of please refrain if you have kind of broader questions, but this is where it's like you start to get into specific questions about your firm. That's where we really recommend that you reach out to the Prince McCall Potroff team, or if you're already working with a GovCon attorney, reach out to them. So a little bit about our show format. So we're going to be going 90 minutes today. The first 30 to 60 minutes, it's going to be in a discussion format with me and Stephen. We're going to be talking about some things that are happening in the world out there, and I'm going to share with you the topic in a second. And then we're going to cut to the live Q&A. So if you are watching this and you're not in our Zoom call, for those of you guys, because I know we're streaming this on YouTube and some other channels, you can actually go to govology.com/roundup, register and get in and take part in the Q&A if you would like to ask questions. So for those of you guys who are with us in the Zoom call, there's two ways to ask questions. One way is you can raise your hand using the control panel. We'll take all of the questions at the end, so we're going to get first through our discussion. The other option for you is that to type your questions in the Q&A box. So for those of you guys live with us on the Zoom call, we have a Q&A box, and basically please put your questions there, not in the chat box, because when I open up the Q&A box, if your questions are not there, I won't probably see it. Also, if you happen to need help, and this is at any time before, during, or after any of our shows or webinars, support@govology.com is always a great email address to reach out to our team. Also, if you want to watch the recording later on or share it with a friend or loved one, you could go to our YouTube channel, and we've got an easy hyperlink. It's just govology.com/YouTube. You can also catch us on Spotify if you want to listen to us on the go. Get tired of the same old songs over and over again, so you could look us up there. Just search for GovCon Roundup. And last but not least, I would highly recommend that you subscribe to Stephen's GovCon Roundup newsletter on LinkedIn. I've got a little URL there to make it easy for you. If you do govology.com/roundup-newsletter. Also, you'll probably find it if you just Google GovCon Roundup newsletter or LinkedIn. You'll probably find it that way as well. This show was inspired after Stephen's newsletter and the things that he writes about on his blog. So, and specifically the topic that we're going to be talking today is another topic that originated out of a recent article that he has written. So make sure you guys sign up for that. It's just a wealth of information. Also, we do these monthly. If you want to check out what we got going on for the coming months, we haven't posted it today, but you can go to govology.com/roundup. Typically around the first of the month, we'll have the new topic for the month. We do these every third Wednesday at the same time, 1 o'clock. So if you want to plan for that, but also if you are in the community, keep an eye out for the emails and we'll send them your way. Last but not least, if you want to continue the conversation in our private LinkedIn group at Govology Nation, we have over 2,000 people there. Steven's there, I'm there, and a lot of other government contractors and experts and our Apex Accelerator partners. So it's a really great place to ask a question outside of a show or a webinar, or just kind of keep up with things that are going on, because we do post from time to time there. Again, if you need any of these links or you're looking for a resource that we've got, just shoot us an email at support@govology.com. All right, let's talk about our topic for the day. It's going to be on the state of the 8A program. And within this, we're going to talk about a lot. We're going to talk about suspensions. We're going to talk about appeals, getting into the program, what the heck's going on with the program today. And then we're going to go to the Q&A. And so we'll be in a Ask Us Anything type of format. So I'm going to stop this share for a moment here and just pull the videos. And let's go ahead and get started. So, all right, Stephen, you ready for this?
Well, let's do it.
All right. So I want to start out, and let me kind of pull my questions over here so I can have them front and center. All right, Stephen. So I'd like to start off here. So for anybody that might be new coming into the 8A program, doesn't have a lot of background or history, can you give just a really brief overview in a nutshell of what the 8A program is? What went wrong specifically in terms of why did the Supreme Court rule that the way that the SBA was administering the program was unconstitutional? And that was, I think, in about 2023, correct?
And yeah, then, it wasn't a Supreme Court decision, but we'll talk about that in a second.
Okay.
Another federal court, yeah, that issued that decision.
Yeah, didn't go that high.
Didn't go that high, no, because no one ever appealed it.
So. Yeah. And then, like, since then, well, like, what was the timeline? So since 2003, you know, we saw some things starting to change and starting to happen. And then 2025 and then 2026, we continue to see not only the effects of the follow-on from that decision, but the change in administration and some things that we're seeing here today. So you want to start off there?
Yeah, and there's a lot to unpack there. I'll try to make it quick. If we're going to get into the timeline, there's just been a lot that's really happened since, you know, kind of the middle of last year that we can talk about kind of one by one. But just let's take it back to that starting point. Kind of for those who are new, welcome. Glad you're here joining us, or just kind of, you know, not really experts in what the 8A program is, although you maybe you've heard of it. Let's just start with that. So the 8A, it's called the 8A Business Development Program, is the official name of the program. And it was a program created by Congress. So it's created by Congress, signed into law, part of the U.S. Code. And what it is intended to do is provide special opportunities for businesses that are owned and controlled by people who are considered both socially and economically disadvantaged. That's one category of 8A. Or by certain entities that represent groups that are historically socially and economically disadvantaged, such as Indian tribes, Alaska Natives, or Native Hawaiians. And so what the program does is it has a structure under which the SBA then certifies companies that meet the criteria. And there's a lot of criteria as to what qualifies as economically disadvantaged. For example, for an individual, there's a net worth test. There are actually kind of two net worth tests. There's an income test. And then we've got the social disadvantage side, which we'll talk about a little bit more in a second when we talk about that court case. And then you've got a whole bunch of other criteria in terms of, you know, the person has to show that they own at least 51% of the company. If they're an individual, they have to hold the highest officer position. They have to direct day-to-day operations. They have to have experience necessary to run the company, all these sorts of things. So that's we'll talk about the eligibility criteria in a moment, but they're pretty intense, strict eligibility criteria for entering this program. And then Native Hawaiians, Alaska Natives, and Indian tribes have different set of criteria for how they would qualify their companies for the program. Why would anyone do this? It's because the 8A program carries certain contracting preferences. And so once you're certified by the 8A by the SBA as an 8A company, you have a term of up to 9 years that you can hold that certification. You can't hold it forever; it's up to 9 years. But during that time, you are eligible both for 8A set-aside contracts, and those are contracts that only 8A firms are eligible to compete for, and there are 4,000-ish 8A firms out there. So, and only so many of them do what your business does, right? So it can be a pretty small pool sometimes of bidders. It certainly narrows the pool from full and open, which is everybody or even all small businesses, down to just those certified 8A companies. So those are set-aside contracts. And then you have the opportunity to potentially be awarded sole source contracts, no bid type contracts, which the 8A program has a powerful sole source component. It's unlike the sole source component of any other SBA certification program. You're going to see many, many, many more sole source contracts awarded under the 8A program because of the way that's structured than under the Women-Owned Small Business Program, the Hub Zone program, or the Service Disabled Veteran-Owned Small Business Program. And we can get into the nuances of the structure if you want, but I'm not going to get into there right now, just to say that it's a powerful preference. You also have potential other benefits as well. For example, the SBA may help you with some business development assistance. The large prime contractors may be interested in being your mentor under a formal mentor-protege agreement, forming joint ventures, using you as a subcontractor to meet their prime contract subcontracting goals. So there are a lot of benefits that can flow to a company from 8A. The idea behind 8A, the policy idea behind 8A, is to find disadvantaged companies or companies owned by disadvantaged individuals, and through this business development assistance over a period of 9 years, put them on an equal playing field with everybody else. So they can come out of there and then now compete for small business set-asides or unrestricted contracts, what have you, without that weight of disadvantage hanging over that. And that's kind of the underlying policy idea behind the program. So we'll talk about the Supreme Court, and then maybe want to pause and then before we get into the timeline of what's happened recently, it's not the Supreme Court, the federal court recently. So let's get back to the criteria for eligibility for the 8A program. So let's put aside the entity-owned companies right now. Those are the ones that are going to be owned by Alaska Native corporations, Native Hawaiian organizations, or Indian tribes. And we're going to focus now on just the quote-unquote standard 8A companies that are owned by individuals. So there are a number of eligibility criteria for that status. For example, you have to have what's called good character. If you're currently serving time in prison for murder one, then you don't qualify for good character, right? So, there are a lot of criteria, but one of the most important criteria is what's called social disadvantage. What is social disadvantage? Well, if you read the 8A regulations, you as an individual can do two things to demonstrate your social disadvantage. One, you can demonstrate to the SBA's satisfaction that there is some objective characteristic about you, and that could be your race, it could be your gender, potentially your sexual orientation, potentially a disability, potentially religion, some objective characteristic about you that in your personal history has led to bias or discrimination against you, that has had a concrete impact, a real impact that has held you back in terms of your education, in terms of your experience in the workplace, working for others, and or in terms of your experience as a business owner. And so that is one way you under the regulations can do this, is show the SBA, look, here's a characteristic about me. I suffer from disability, for example, and here are times where I was discriminated against because of that. Now, importantly, when you do that, you don't have to prove beyond a reasonable doubt that you were discriminated. It's just kind of a more likely than not sort of analysis, and the SBA is required to take your word for it, unless there's what you say is absolutely ludicrous, or they have evidence that points in a different direction. So you don't have to have, your former boss doesn't have to admit that they discriminated against you for a promotion because you're a woman, for example. If you show facts that make it clear, hey, I was more qualified, I applied for the job, but they gave it to Bobby because Bobby's got to support a family or whatever, because of that some outdated norms about who's the breadwinner. that might be enough to prove it. So that's one way. You prove your individual social disadvantage. The second way under the regulations is literally just to be a member of a group that has historically suffered from discrimination, bias or discrimination in this country. You don't have to prove, if you're a member of one of these groups, or didn't have to prove under the regulation, that you personally had experienced bias or discrimination. That could be certain Asian Americans, Black Americans, certain Hispanic Americans, a whole group of that's literally listed in the regulation of groups of racial or ethnic identity. And so that was the piece that went to a federal court in 2023. It was a case called the Ultima case. And in that case, a federal judge said, look, to write a regulation or a statute, to write into the law in this country a racial classification, you have to have like the highest level of need for that. You have to meet a really high threshold of proof as a matter of constitutionality to show that it's appropriate to literally put in the regulation a list of a racial criteria and say, yeah, you qualify, you don't. And the judge said in this case, Congress, when it originally wrote this statute, and the SBA, when it implemented, it had not met that threshold. They had not demonstrated sufficient proof that they had reached the extraordinary need to write a racial classification into the law. And so the judge said that part of the 8A program, that if you're the part that said if you're a member of a group you automatically meet the social disadvantage criteria, is unconstitutional. And so that's where that federal judge issued that ruling. The SBA could have chosen to appeal that ruling to this appropriate circuit court and then potentially up to the Supreme Court. The SBA chose not to do it. And I don't know the reasons why, but my guess is because they thought they would lose. I mean, that's my guess. And there's not a political motivation here either, because this is under the previous administration, which is not necessarily, having the same political interest in rooting out DEI or whatever as the current administration. My guess is they thought they would lose. And I for years have thought, I don't know that SBA has the proof that they need to support this racial classification in the law. So that didn't mean the 8A program went away. All it means is that at that point, that path toward demonstrating social disadvantage was gone. That in order to demonstrate social disadvantage after that court case, every individual applicant has to personally prove that they had that they have some objective characteristic, whatever that was about them, and that they had personally experienced incidents of bias or discrimination that had set them back in terms of their education, their workplace experience, or their business life. And that's where things have stood in the program following that case in 2023, and kind of up to where we find ourselves maybe in the middle of 2025, when things started getting a little hairy after the change in administration.
Yeah, which is interesting because, Stephen, when I worked at the SBA back in around 2010, what was interesting is that when we would help firms apply for the 8A program and sit down with them, we would always actually have them complete the social disadvantage narrative. So I thought that was pretty much a standard across the country, but I guess it wasn't. I mean, was there people that were getting into the program that didn't have to write any social disadvantage narrative at all? And was that the problem?
Yeah, I mean, and that's how it ended up being. So the SBA had been kind of inconsistent about that for a while. Sometimes they would, at points in time, they wanted a social disadvantage narrative, even from people who fit into one of those categories that said they were presumed. But then they stopped doing it for a while. Like I worked on many 8A applications with clients who fit in the presumed category, and all they had to do was essentially swear under penalty of law that they met that they fit in that category, and that was it. There was no narrative required, because SBA said, well, that's belt and suspenders stuff. You already meet the presumption, so you're presumed that you're socially disadvantaged. You don't have to personally prove that you experience those narratives. SBA always reserved the right to come back and say, no, we want you to prove it. But at least for many years there, in my experience at least, they weren't doing it. In fact, I had cases in which the SBA would do things like, this is going to sound bad, but we're talking about race now. So they would literally say, like, send me a picture of your client. Like, I want to see that they look Asian, basically. I'm like, wow, like it's, but that's what they were asking for sometimes instead of the narrative. And
Mhm.
so yeah, there were people who were getting in without the social disadvantage narrative based on swearing that they were part of a group that was socially disadvantaged. Sometimes the SBA did require more, especially when it came down to, there was, they could ask for evidence that you held yourself out to the public as member of that group. And so some of these groups are based on national origin. So, hey, you're Pakistani American, do you hold yourself out to the public that way? You have to supply evidence that, no, I belong to a Pakistani students group when I was in college or something. I'm not hiding it from anybody. But those are kind of case by case basis. Some times all you had to do was check the box, sign the form under penalty of law, which is signed under penalty of perjury. So it's not an insignificant thing to be swearing to. And sometimes that was it under that presumption.
Yeah. So then, since then, now everybody has to submit the social
Yeah.
disadvantage narrative, which, by the way, we're not going to go deep into, what those entail to meet the eligibility. We have webinars on that. If you guys want to reach out to us, Stephen does a great webinar, and you're going to do another one with us in April on all of the certification programs. I definitely recommend that you guys watch out for that one. But yeah, so now everybody does. But what's interesting is that it was always available for any contractor that basically had instances of discrimination, not only the minorities. So basically, the regulation would have the presumptive groups of the minorities, but it said if you didn't fall into that group and you've received bias or discrimination and you meet the definitions, you know, you can also apply, and then they would consider it on a case by case basis. Is that correct?
Yeah, that's exactly it. And I think it's a misconception about the 8A program and that it's a program, quote unquote, for minorities. And I've had people tell me, hey, this is in the past, there's been some changes recently now, of course, starting with that court case and moving forward. But, well, I'm not a minority. I can't get into the program. But if you met that criteria, that you had an objective characteristic about yourself, and that you experienced bias or discrimination as a result of it, then you were eligible to apply to that program. And I think, in the past there were some times where SBA made it really hard to get in on that track, and
Mm-hmm.
other times where it was less hard as a matter of practice. But in my experience working with many 8A applicants, I helped many Caucasian women get into the 8A program. This is before the current administration. This is before there were that Ultima case we talked about. I helped many Caucasian women get their businesses into the program, showing that they had been discriminated against on the basis of being a woman. And I helped a number of disabled veteran Caucasian men get into the program, showing that on the basis of their disability, they had been discriminated against and that they met the social disadvantage criteria. So it's never been a program, quote unquote, for minorities, but it was, to be honest, a program in which members of certain minority groups had a leg up with respect to one of the many eligibility criteria, because there's social disadvantage, there's economic disadvantage, there's good character, there's net worth, there's income, and there's management control. There's a lot of eligibility criteria, but on the social disadvantage side, members of certain groups didn't have to sweat out the narrative part. They didn't have to come up with the times they'd been discriminated against necessarily, or compile all that information or convince somebody that they were socially disadvantaged. They just in many cases just had to attest that they were a member of the group. So that's where things, the minorities had a leg up with respect to one of the many eligibility criteria. But it was never a gatekeeping criteria. It was never intended to be that way. It was just it was an easier path with respect to that one part of the application.
Yeah, so there's a couple of other things I want to circle back with, and specifically what happened at the end of 2025, and then, what's happening right now. But before I get to that, let's take, where is the program today just in terms of the definitions for the criteria? I don't think that has changed in law, but we have seen some information that was posted by the SBA in January, talking about, some of the Biden area, which I don't know what really that meant, because this has been gone on for like, many
Yeah.
years. I mean, this program was in place even before President Biden was president. But now it speaks to something about if you were discriminated against by NARA DEI or set asides or some of these other things, you're eligible. How does that work? I guess can you help me understand that in terms of
Yeah.
one, it's not law, it's something that was put out there, but are they looking to change law? Has the law changed any? Are they going to change the law to expand the definition? What are you seeing in this?
Yeah, and so yeah, and I don't have any inside information. SBA unfortunately doesn't call me and tell me what what they're doing. I mean, I do agree that some of these SBA press releases, just the way they're writing them right now, you have to kind of parse through them a bit and try to take out kind of the political rhetoric, which kind of is what it is. They're representing a certain administration point of view, but you kind of have to mentally filter some of that, I think, and get to the substance, because there's a lot of that goes on. And yes, like we say Biden era DEI, but they were doing this. The program was run the same way in the first Trump administration, right? So under George W. Bush too. So it's just kind of but they're trying to go a different direction here, and so I think we have to get down to brass tacks though, and the idea, the thing that the major change that's happened is really well is the ultimate case. It's that federal court case that said
Yeah.
there is no more presumption of disadvantage for anybody based on their race or ethnicity or national origin, because it's unconstitutional. And so I think that um, some of the angst over the 8A program is coming potentially from folks who don't understand that case and what it meant.
Mm-hmm.
And that it could be, it's sort of reasonable in a way, because when that part of the regulation was declared and statute was declared unconstitutional, it's unenforceable. The SBA has not enforced it in almost 3 years now, but it's still on the books. And so if you read the 8A regulations, you might say, wow, they've just listed out a bunch of categories of race and ethnicity. This is a DEI program like I've never seen before, without understanding that it's gone, that regulation is unenforceable. And so, yeah, I have heard that SBA is, as they should. I mean, they probably should have done this earlier, planning to issue a regulation to wipe out the rule that the court has already said is unconstitutional, and that SBA itself decided not to appeal. Why that's taken 3 years, I don't know. Rulemaking can take a
Right.
while, but then you're simply repealing a rule that was declared unconstitutional. I don't know why that needs to be a delay. And even under the current administration, which has maybe more of a political will to do away with something that looks to them maybe like DEI, it's still been a year and they haven't gotten rid of that. So,
Mm-hmm.
but I have heard that's coming. Um,
So
you
when
know,
you say get rid of it, do you mean
yeah,
go back to the regulation and just take out the piece that they had, like these groups have the presumptive disadvantage, and just make it everybody can apply if you've got discrimination or bias, but you just have to cite this instances? Um,
yeah, that's probably what it would look like. Is they would just wipe out. I mean, and that may be some of the conversation that's going on. Like, what do we as SBA have statutory authority to do here? If one possibility, although I think this would require Congress to come in, would be just be to eliminate the concept of social disadvantage entirely. It's like, you know
yeah.
what, we're not comfortable with it. It's just going to be for economically disadvantaged businesses. You meet the net worth and income threshold, then you're in. And this is like 10 years ago, I predicted that was what was going to ultimately happen to this program because of the tension surrounding the social disadvantage criteria. But again, I don't know that SBA has the legal authority to do that, because the social
Yeah.
disadvantage piece is part of the underlying statute. So
Mm-hmm.
they may be still considering what to do with that. But yeah, I think what they would need to do then is come in and strike the part of the regulation that says, it currently says there's two ways to become socially, to be qualify as socially disadvantaged. One, prove it to you're presumed because of your membership in a group, and it would just eliminate that second item and say, no, everybody, there's only one way to qualify as socially disadvantaged, and that is to prove it. And then maybe, if you still don't like that as the administration, then you can potentially work with Congress to try to say, let's just turn this into a program for folks who are economically disadvantaged. Let's just
Right.
not even worry about social disadvantage. And that would be potentially the next step that could be taken.
Yeah. I mean, that would be, I think, a good option for that as well. We've talked before. It'd be like Hey, it would be great if they expanded the definition out a bit because the 8A program is a good program. Not only is it beneficial to the businesses that get into it to use it as a springboard, because the biggest disadvantage everybody has coming in is the past performance and past experience disadvantage. And this, in a way, through the sole source contracts vehicle, is a way for those small firms to get some of that so that once they graduate, then they can actually go out and compete in the um, general small business marketplace, but even in full and open competition. So I think I'd like to see something like that where it just opened it up to all to allow more businesses, because there are a lot of disadvantages that are not taken into account just beyond economic and social disadvantages that I think small businesses face in this marketplace.
Yeah, I mean, it has been a very successful program, and that's the thing is it's been successful, and not everybody goes into that program succeeds, but a lot of companies have done exactly what the program was intended to do, which is get a foothold in the government contracting marketplace, build toward a place where they're successful, growing, and can compete for unrestricted contracts, or at least small business set aside contracts once they exit that 8A. So it really has been, and I've been there as companies, fledgling companies who now are massive businesses. 15 years later, have used that 8A program exactly as intended for a springboard. So I think, especially as we're facing a world in which every year, almost like 14 of the last 15 years, the number of small business prime contractors has declined.
Mm.
That we have usually there's an increase in the dollars that are being awarded to small businesses, but the actual industrial base, the small business industrial base, has shrunk more than 50% over the last
Mm-hmm.
50 years, more than 50%. So there's only half the number of small businesses that are selling to the government now that did before, and there's a lot of factors that are responsible for that. From contract consolidations, things that aren't going to using these best in class vehicles, all these sorts of things, up to just the past performance conundrum that you mentioned, and how do the emphasis often on the kind of chicken and egg thing, where you really need government past performance to sell to meet the criteria for past performance, or to get a good score on a past performance criteria, something better than a neutral. But you can't get government past performance unless you win a contract, so this chicken and egg thing. So there's a lot of reasons that could go into that, but having a program like 8A that was more available to companies that want to enter that federal market and want to be able to succeed and need to build that record of past performance, need to build that experience, maybe could help, stem the tide here, where every year we're seeing fewer and fewer companies that are small businesses that are selling to Uncle Sam.
Yeah. I want to talk about the status of sole source contracts right now, because you mentioned that as one of the benefits of the 8A program. It's the sole source authority within that program is not like any other program. It's uh, basically the contracting officer doesn't have to write like a justification. They don't have to say there's like I couldn't find 2 or 3 firms that could do this work, and they could just go right to the firm. Now that also benefits the government at the end of the year. And if you look at any 8A spending, you see a lot of 8A because the government's got the money. It's been all backlogged from the shutdowns and everything else, and then it gets released and it helps them expedite. So it's interesting because we're going to see how this plays out. But can you talk about the status of sole source right now? Because I think last year we saw a bill introduced to stop sole source contracting until the audit was done, but I don't think that bill has been passed. But there's been some people from Congress who've reached out to agencies saying not to award sole source contracts until the audit's done, which who knows when the audit's going to actually all get done. You have any insight on that?
Yeah, so just first things first, yeah, structurally, as I mentioned kind of at the outset, so the 8A program, alone of the four major SBA certification programs, which includes also the Woman-Owned Small Business Program, Hub Zone, and the SDVSB, Service Disabled Veteran-Owned Small Business Program. The 8A program has the most powerful sole source component by far, and that's because the other three uh, certification programs, while they allow sole source contracting, they only allow it at all dollar values when the contracting officer has no reasonable expectation that if they put this out for competition, they will get two or more offers from qualified, capable hub zone firms or SDVSBs or women-owned small businesses. And so the 8A program does not have that barrier, and there's differences in dollar values about what they've got to do here and there. But essentially, for a lot of 8A work, the contracting officer can say, "Look, I like 8A firm X. They've done good work for us before. We know them. They can do this at a good price. Yeah, if I put this out on the street, I might get 10 other 8As who bid it, but it doesn't matter. I'm awarding the contract to firm X." And that's why you see the 8A dollar awards are so much higher than the other certification programs. Is because structurally it's a much more powerful sole source ability that contracting officers have. And you're absolutely right, Kara. At the end of the fiscal year, they really love it, because it's an easy way to award some of that money that's going to disappear if they don't obligate it by the end of the fiscal year. So, what I've always long said, and I'm saying more often now that we see kind of more attacks on the 8A program, is that you don't benefit hub zones, you don't benefit WSBs, you certainly don't benefit SDVOSBs by tearing down the 8A program or attacking the 8A program. What should be done, if you're an advocate for one of those other programs, is to equalize their sole source authority with the 8A authority. And that would take an act of Congress. Congress would have to step in and write that statute, but Congress could easily do that. Congress could say, look, we want to support veteran-owned small businesses, so we're going to change the sole source component of the SDVSB program to match the 8A program. And there's no reason Congress can't do that. And so, but you see these attacks on the 8A program saying, it'll be good for veteran-owned businesses. Some say if we do less work with 8A firms, and yet there are more than 400 veteran-owned businesses that are 8A. It's more than, and veteran-owned businesses got more than $2 billion from the 8A program in the last fiscal year for which we have data. So that's not helpful. What it would be helpful for those companies would be to expand that. So that sole source authority has come under some fire. I guess we never got to the full timeline. So, but one of the things that happened, I believe it was November, December, was Senator Joni Ernst of Iowa introduced a bill that would say we're gonna put a halt on all sole source 8A awards until the SBA finishes this lengthy audit that it is doing right now. The SBA has ordered all 8A firms. They did this in December to provide detailed financial records. Those were due in January 19th, and so who knows when this audit will be complete. But SBA is going through, to fine-tooth comb all the records that were submitted. And so Senator Ernst said, my bill would halt sole source contracts. We would require agencies to halt 8A sole source contracts indefinitely. That's what the bill says. That bill, to my knowledge, is not gone anywhere. It's out there. I don't think it has the support to pass both houses of Congress. That's just my guess. Senator Ernst also separately sent a letter to the head of each of the 22 federal agencies that use the 8A program, asking them to voluntarily pause 8A sole source contracts, because the bill would force the agencies to stop doing it, but the agencies on their own volition can just choose to stop using 8A sole source. There's nothing that requires them to use 8A sole source. It's just a convenient contracting tool that a lot of agencies like to use. And so she's asked the agencies to voluntarily do that. I have not seen any agency announce that they are doing that. However, I have seen some agencies that have issued their own statements, but expressing some 8A program skepticism or whatever, but none of them that I have seen said, yeah, we're actually following Senator Ernst's call to pause 8A sole source contracting, probably because in a lot of cases they're getting pushback from their contracting shops saying, no, that's really going to hurt us. Like we need that tool in our toolbox. Why would we voluntarily give that up?
So what you're saying is that there's not an official, formal, legal prohibition to 8A sole source contracts. So you could expect to see some continuation of sole source contracts happening in this fiscal year.
You should, yeah. And so there's no prohibition on it. The Senator Ernst has put pressure on the agencies to not do that, of course. But as far as the bill is not passed, I can tell you that the bill is not passed even the Senate, where it was introduced, much less both houses of Congress. So the bill is just hanging out in committee right now, which is where most bills die ultimately. Thousands of bills that are introduced every year, only a fraction a small fraction become law. And I have not seen the agency voluntarily, say we're going to suspend sole source contracts. That doesn't mean that we'll necessarily not see any impact from this. I mean, I think realistically there is, some sort of pressure on agencies to potentially reduce their 8A contracting, whether agencies, you know, feel that pressure or not, whether they act accordingly to that pressure, I don't know, but I think you could see some impact on 8A contracting just because this sense out there that 8A is in flux and that it's being challenged, and that maybe certain political figures don't like the program, and so maybe the safest thing is just to not use it as much. I don't know if that's true or not. It's just speculation on my part. But I think you're still going to see plenty of 8A sole source contracts this year. Again, there's no agency that I know that has said we're shutting that off. And the bill is, like I said, it's still sitting in committee.
All right. So with all of that now, I want to go back to your article that you've written recently titled on your FedLift blog, by the way, which is another great place to subscribe. But it's titled The 8A Program Suspension Appeals, a Primer for Your FedLift Launchpad blog. And so what we do know is a result of this requirement that a lot of the 8A firms had, like December 5th, within like 30 days across the Christmas holidays, to hurry up and submit all this stuff to be reviewed. Some contractors got it in, others didn't. But as of now, there's been over 1,000 companies that's been suspended from the 8A program. And in this blog, you were talking about this suspension process and the appeals process. So you want to talk a little bit about that article in terms of, what does suspension actually mean to a contractor? Well, what happens to, future contracts? How does that appeals process work? And while we're talking about appeals, it's not only for suspended firms, but you can also appeal if you get denied, if you've applied to the 8A program. So it might be worth a mention, I thought.
Yeah, absolutely. And thank you for mentioning that. I do have a new blog out there that just launched last month in January called the FedLift Launchpad, and it's got it's where I write my articles first, actually, that later appear now on the GovCon Roundup LinkedIn newsletter. So you can go, it's a Substack blog, so it's fedlift.substack.com. But yeah, this article appeared there, and it was later published in my LinkedIn newsletter as well. But it focuses on as Carol said, in December, SBA issued this data call for 8A companies. There are about 4,300 active 8As at that point in time. It said you have to submit all this documentation within 30 days or so by January 5th, I think was the original deadline, and then pushed that back to January 19th, which was, a federal holiday, Martin Luther King Day, and said you have to submit all your documentation by then. They gave them a couple more weeks to do it. They after the 19th passed, the SBA immediately, or almost immediately, within a couple days, suspended over 1,000 of those 4,300 8A participants from the 8A program, saying these participants had not timely submitted all the documents required by the December data call. Now, my understanding, talking from those who've seen SBA's database, is that of those, 1,000 plus 8A participants that were originally suspended, a couple hundred of them the suspensions have already been lifted. My speculation is that this is just speculation, is that these are probably, and this is just speculation as well as hearing from a few voices out in the field, is that at least some of these companies were ones that had tried in good faith to submit their documents in time, had potentially technical problems with the SBA's own system uploading it, and for that reason were late. But they did submit all the information that was required, and so I think that in that case, SBA, either of its own volition or because they got legal advice saying you're going to lose an appeal on this stuff, decided to reinstate it. So that means we probably have 800-ish or so contractors that I haven't looked at the data myself recently that are still suspended. And so this article was intended to say, okay, well, we suddenly have 800 suspended 8A contractors. Probably a lot of people don't know what that even means. What is suspension within the 8A program what's the effect? How do you appeal a suspension of if you've been suspended from the 8A program? So suspension from the 8A program is a tool that SBA has available where it can essentially pause a company's ability to receive benefits under the 8A program, um, pending potential termination for the program, or potentially lifting that suspension once SBA is satisfied that the company is not a problem. That's historically been used most often, in my experience at least, preceding a termination, and often when the SBA discovers that a company gave false information in its application originally, that the company falsified either intentionally or negligently the information presented in its application, was never eligible for the program, should not have been receiving the benefits, and so SBA has to go through a special process when it terminates a company. There's a due process type process that has to play out. SBA can't just snap its fingers and terminate a company. Company has legal rights and to fight that termination, but SBA can kind of snap its fingers and turn off the benefits of the 8A program with the suspension. So historically, again, in my experience, when SBA is like, wow, this company is going to get terminated, we're proposing them for termination, they never should have been admitted in the first place, but we don't want them receiving more 8A contracts in the meantime. We don't want them taking advantage of the 8A program. We're going to suspend them pending that termination. Although suspension can be used in other cases as well. Suspension means that the company still has its existing 8A contracts, and they're still obligated to continue performing those contracts. However, they're not eligible to win new 8A contracts during the date of that while a suspension is in place. And so anything new, not allowed to do, but they still hold on to your existing 8A contracts. It applies only to the 8A program. So it's important to differentiate it from a government-wide suspension or debarment, which would bar you from all government contracts. That's not the case here. This just says you're essentially temporarily no longer 8A. You can finish up your existing 8A contracts, just like you don't have to be 8A throughout the life of an 8A contract. You can graduate from that program and still finish your contract, but you can't get new benefits from the 8A program while the suspension is in place. And so when you're suspended from the 8A program, if that happens, you have the right to appeal that suspension. And the appeal goes first to an office called the Office of Hearings and Appeals, or OHA is the acronym, which is an office inside SBA that has one or more administrative law judges who are SBA employees, but who are tasked with acting independently, who will hear those appeals. Right now, to my knowledge, there's only one administrative law judge full-time at OHA, Judge Christopher Holloman, who's been there for probably 20 years or more. And, to my knowledge, even though he is an SBA employee, in my experience, I've been in front of Judge Holloman many times when I was practicing law. He is fair-minded, and he does, I think, try to act independently, as that mandate would say. I also understand that because of the volume of appeals that may be pending here, SBA is maybe going to essentially lease judges from other agencies to come in and assist Judge Holloman in hearing these appeals. And so that's where the appeal would go. It would go to the SBA's Office of Hearings and Appeals. Has to be filed within 45 days of the notice of suspension. Late appeal will be dismissed. There's no ifs, ands, or buts. The judge doesn't have a right to hear a late appeal. Importantly, in these suspension appeals, the government has the burden of proof. The SBA has the burden of proof of showing that suspension is necessary to protect the interests of the government. And this all sounds like legally wonky stuff, but the burden of proof is really important. Usually when you're appealing something the agency allegedly did wrong, you have the burden of proof. For example, if you are denied from the 8A program, you as the appellant have to prove the SBA made an error in processing your application. And so, closed case is going to go to the SBA in that situation. Here it's the opposite. The SBA has to prove to the judge's satisfaction that the government's interest it's required the suspension to protect the government's interest. And remember those examples I talked about where a company was ineligible for the 8A program, they falsified information in their application, and now the SBA has an easy way to meet that burden. They say the government's interest is protected when only eligible 8As receive 8A contracts. Hence, the suspension is necessary because this company is ineligible. They should never have been admitted in the first place had they not falsified their application, right? That's a typical way the government would meet its burden in that case. But there have been many suspension appeals that I've looked at, and I went and did some looking after this whole incident came up with the 1,000 suspensions, in which the burden of proof was essentially the deciding factor. The judge said, "Yeah, sorry, SBA, like we see what you're saying, but you're showing us sounds like suspicion, sounds like innuendo. It doesn't sound like real proof to us that the government's interest requires suspension. Victory for the suspended company. SBA, you're ordered to lift the suspension." And so, these cases are going to be really interesting because the suspension was used as a broad tool to essentially punish companies that didn't, in the SBA's at least allegations, didn't comply with the data call. And so now the SBA has to convince the judge that the government's interest is protected only if those companies no longer have access to the 8A program's benefits. Well, what if one of these companies submits their data 2 or 3 days after the deadline? Okay, now you got all the data to assure yourself that we're eligible. How is our suspension necessary to protect the government's interest now? And I don't know, but I speculate that may be behind some of the reinstatements. Folks that had submitted their data or tried to submit their data on time, they couldn't do so because of the SBA system. I think the OHA judges are going to be hard pressed to say that the government's interest requires suspending those companies when they tried their best to submit on time and had trouble with the SBA's upload system for documents. And now SBA, you have the documents in your hands, right? So how is it protecting the government? So it'll be really interesting to see how these cases go forward. I think one of the key potential problems for the suspended firms is just the resource allocation over there. You've only got, again, to my knowledge at this point, one full-time judge who's an expert on these matters in OHA. Even if they bring in another judge or two from other agencies to hear these appeals, you could have hundreds of appeals coming all at the same time with maybe judges who are not experts in this subject matter hearing some of these appeals. So it could mean that some of these companies just don't get their day in court really for quite some time. And the suspension process says, the judge will issue a decision within 90 days when practicable, if they can. And, in my experience working with OHA, they try their best to meet those thresholds. There's a similar threshold for other types of OHA appeals. But again, this is an office that published less than 100 written decisions in the year leading up to this. They don't issue a ton of decisions in the year. And so if they publish, 90 decisions in 2025, and ruled in 90 some cases, whatever it was, and now they've got, let's say, 500 appeals coming in. The resources allocation alone could mean that it takes a while to get those processed. I just don't know. Or maybe there'll be some way to consolidate those cases because so many of the facts are similar. We'll just have to see how this all goes forward. But that's kind of where things stand with respect to suspension. This tool that has always been there in the SBA's toolbox for managing the 8A program, but has never had its day in the sun until now. And now that's why I wrote the article to kind of let people know what suspension was about, the burden of proof, timelines, all those sorts of things.
When people are suspended from the program, let's just say it takes a year for OHA to have a decision, does that kind of temporarily pause their 9 years of eligibility in the program?
Oftentimes, yeah. And so that's going to be on a case-by-case basis. But oftentimes the company does essentially get the lost time back. That's
Okay.
part of the lifting of the suspension is that, hey, we're lifting the suspension. You had 3 years left in the 8A program when we suspended you. We're not going to say that year, is now you're down to 2 years. And so it's going to be there. The rules are a little nuanced on that. But I think that in this case, my guess is that if these companies, a lot of them anyway, if they were to get their suspensions lifted following an appeal, they would probably be entitled to have that time tacked back on to their 8A application. I think it's also worth noting, although it wasn't in the article, that if these companies lose the appeal at OHA, that's not the end of the road if they don't want it to be. After they have to go to OHA, that's a mandatory first step. But if you don't like the decision you get from OHA, it's considered a final decision by the agency, the SBA, and that entitles you to then go to federal court. So we could see companies that lose at OHA that say, no, now I want a federal judge to weigh in on this. I'm going to go to a federal court and sue the SBA in federal court, and that would be the next step for any company that loses this OHA appeal. But they have to go to OHA first. There's not a you have to get a final decision by SBA before you can appeal, and that the OHA process is the final decision.
Yeah. So I'm going to bring back up at this time, and I know that some folks joined us late, so I want to bring back up our screen here. Stephen, are you able to see the Q&A screen here?
Yep.
All
Looks
right.
good.
So we'll segue into the Q&A now. And as I mentioned at the beginning, Stephen Kopretz is now retired from his legal practice. And so if you guys need help with matters such as appealing a suspension or anything else like that, if you've been one of the firms that have been suspended, one of our recommendations is to seek out a good GovCon attorney. We have some great partners over at Kopretz McCall Potroff LLC, and there's some information on their phone numbers if you need an attorney to reach out to. But let's go ahead and start to get into some of the Q&A here, Stephen. And before I kind of jump into the ones that we have in the queue here, there is one more question I wanted to ask you as we kind of close out the main segment. If you are what would you do? I'm going to do a what would you do scenario. So and there's two scenarios here. So like the first one is that let's just say you had applied to the 8A program and you're pending certification. In fact, we have one of the first questions regarding this. And you're just kind of sitting there in this holding pattern. Would you wait? Is there a way to say, hey, I don't really like the environment right now, and maybe I would prefer to wait till the dust settles? Is there a way to kind of pull your application back and come back in and apply when things may be more favorable? And
Yeah, I
this,
mean, I
yeah,
think
go
you
ahead.
could withdraw your application. I don't see any reason why you couldn't just, withdraw that application and say, yeah, this is not the right time. 8A program is kind of, under pressure right now. I'd rather just kind of see how things shake out and then reapply when the landscape is a little clearer moving forward as to what the benefits of this program will be. And that's going to have to be a case by case basis for folks. Obviously,
Yeah,
there's some people who are like, now if I forecast it out, I'm going to exceed my size standards in 7 years, and I really want to maximize my
yeah,
time in the program, so I got to do it now. Others, are not in that position, and so I think it's really, up to each company to decide, hey, is this the right time for me to apply to 8A, or should I maybe just hit pause on this certification, look at other potential certifications I might be eligible for now, or other ways of involving myself in the contracting market, such as a subcontractor to large primes,
yeah.
and circle back this 8A certification. We'll put a little note to circle back in 6 months or a year and see where things stand and reevaluate at that point. But that is going to be just a case by case thing.
Yeah, absolutely, man. I think you hit the nail on the head there. In another scenario I was thinking about, because I was going to also say, for the firms thinking about applying, is now the right time to apply. But I mean, I believe what you just said, it's really a case by case basis. If you are out there and you don't really see anything happening right now, I mean, one scenario I would think about is like there are, uh, a number of 8A IDIQ contracts that could be coming up for a recompete. And so if you say, like, let's just say at the end of the year, there's going to be a recompete and there's only going to be a 5-year window to go back and compete again for those 8A contracts. If you sit on the sidelines and you're not certified and you see this set aside come through, well, now you're going to have to wait 5 years again. So really is a case by case basis. So I encourage you guys, talk, with whoever you're working with. If you're working with coaches, consultants, attorneys, your Apex accelerators out there, really think about all the aspects of the consideration that you might be looking at for the 8A program right now. So, okay, first question out of the queue. If you already have your 8A cert, can you pause it?
No, there's not a way to kind of like voluntarily pause your certification, other than there's a provision for if the disadvantaged individual is a member of the armed forces, for example, serves in the National Guard, is called up, and then is sent for an active deployment. There's a way you can pause it then, but yeah, you unfortunately, and I think good question. There's not just kind of like, yeah, this isn't the right time. I want to pause my 8A. Check the box that most folks can do.
All right. Is there a new FAR regulation that states agencies are no longer required to keep existing 8A contracts within the 8A program?
Yes and no. I mean, this is a kind of change to that once 8A, always 8A rule. And so for those who aren't familiar with that, the once 8A, always 8A rule is not, that's not the formal name of the regulation. That's just what's known as, is a regulation that says that generally speaking, once a contract is placed in the 8A program, any follow-on contract for the same work, same or very closely similar work, uh, must stay in the 8A program unless the SBA agrees to release it, or there are other circumstances. There are a few other circumstances that would allow that contract to be released. Now, obviously, in certain industries, that's not an issue. If you're in general construction, usually that's not going to be a problem because there's not going to be a follow-on contract unless it's some sort of ongoing maintenance or something. But for some, especially in the service industries, it's 5 years, 5 years. These contracts that follow kind of one after the other. That once 8A, always 8A concept can lead to work being remaining in the 8A program. The revolutionary FAR overhaul process, which took place last year, in the revision of FAR Part 19, where the small business rules are, that revision does create a new exception to once 8A, always 8A. The exception, and why I kind of said yes and no, says that the contracting officer can, without SBA's permission, remove a follow-on contract from the 8A program if the contracting officer will set it aside for either WSBs, HUD zones, or SDVOSBs. Those are the three new exceptions. Now, the contracting officer cannot just remove it and go unrestricted or even small business set aside. So it weakens the once 8A, always 8A rule, but doesn't eliminate it because it gives the contracting officer more power to kind of decide between those four SBA certification programs, but not just to willy-nilly remove the work from 8A to go unrestricted, for example. Right now, it's an open question whether that provision is actually available to contracting officers as a legal matter. And the reason for that is because that provision appears both in the FAR, which has been revised under the revolutionary FAR overhaul, and the agencies that have adopted that deviation have that in their FAR right now. But it's also in the SBA's regulations and the Title 13 of the Code of Federal Regulations, 13 CFR, and the once 8A, always 8A rule under the SBA's regulations has not been yet changed. And so there's a conflict, a very clear conflict between the FAR and the SBA's regulations regarding this once 8A, always 8A, the exceptions that the FAR Council created in the revolutionary FAR overhaul. Historically, when there has been a conflict between the SBA's regulations and the FAR regarding a small business matter, the courts and the GAO have found the SBA's regulations control. That is because these are portions of the statutes that are delegated primarily to the SBA to enforce. And the 8A program, more than just about anything, because it's an SBA run program. So, if a contracting officer were to do that right now, to say I'm pulling a follow-on contract out and placing it in a SDVSB set aside, for example, and a bid protest were to be filed, my money would be on that protest being sustained, because I would think that the likely outcome would be that the court or the GAO would say the SBA's regulation controls, and the SBA's regulation still says that once 8A, always 8A does not have those exceptions. That said, my understanding, at least from fly on the wall type, just kind of hearing what's going on from folks who have a reason to know, is that the SBA is planning to issue a corresponding change to its regulations. Just hasn't done so yet, just like it hasn't done so with respect to that social disadvantage matter we talked about. So until that item is issued, that regulatory change to the SBA's regulation, it's an open question that may be resolved in a bid protest at some point, whether that authority is active right now.
All right. We have a couple of questions that are kind of related to some housekeeping issues. I think Somebody was telling us that the presenter is main screen, not slides. So this was not your traditional webinar. This is our GovCon Roundup live show. So we show some slides at the beginning for housekeeping, but then we go to here just the open video there to complete the show. But I will come back here and give you guys some links because somebody did ask, will we be receiving a recording of the show? We are recording this as of now, and this goes directly to our YouTube channel. And so you can go to govology.com/YouTube if you want to catch the recording of the show. You can also listen to it on Spotify as well. Next question, Stephen. I am currently an 8A applicant who applied back in November of 2024. My application was deemed complete and sent for final review in February of 2025. Since that time, I have received 0 requests for additional information, and all updates are from me calling or emailing the certifications help mailbox. They continue to tell me my application is in final review at the final step awaiting decision.
Yeah, and so this is kind of the news that hasn't made the news really, but it's out there on social media if you look for it. And I have not seen, this is my last conversation on this was last week, so maybe it's changed since then, but I probably would have heard if it had. My understanding is that the last time the SBA admitted a new company to the 8A program was August, mid August last year. They have admitted 0 companies, new companies to the 8A program since August. But that was part of a resource reallocation over at SBA to essentially clear the backlog of STVSB and VOSB applicants, was at least the justification that was given. SBA also went through a dramatic reduction in its overall workforce last year. And so it has been a number of months now since anybody has been admitted to the 8A program. My understanding that I verified that with folks in the know last week. And so I have not heard any different right now. That it's been several months since anyone has gotten in. So it sounds like you're caught up in that same situation. That at some point the process should start rolling again, but I have no idea when. That there's this, and that this probably should be front page news at some point because you hear all these things about memos and the sledgehammers and all this sort of stuff. But the
Yeah.
fact that nobody's getting admitted to the program for a period of many, many months, that's important. And so I wish I had information to you as to when that process will start up. I imagine at some point it will. But when I unfortunately just don't know. And like I said, my best information, August was the last time
Yeah.
any single new 8A company was certified.
Which kind of goes to a second point to the question, which was like, do you know when it's gonna kind of get going again?
Unfortunately, no
Yeah,
information there.
and I think that's one of those situations where you mentioned this regarding the OHA, but the SBA likes this language that's like, hey, we're going to get the certifications done within, was it 90 days or 60 days when practicable?
Yeah, it was always, I forget what the time frame was on that, 180 days if
Yeah.
practicable or 90 days or whatever. But that's always been, the SBA program, and the reason I don't know the number off the top of my head is because it's never been real. Like it was just kind of like it takes as long as it
Yeah.
takes to get your 8A application done.
Yeah.
And so there are times when I've known folks that had their application in and they were certified within a couple months. That's
Mm,
rare. I knew other folks, this is not now with this actual pause going on, but just in previous years when I was working as an attorney, it took more than a year to get certified. And the SBA, they have a deadline, but the deadline is to process a quote unquote complete application. And so the workaround for SBA over the years, in addition to the fact there's no real way to enforce that deadline, was that they would review the entire application kind of on their time frame, find one or two little things that they said were missing, which may not be things that they ever asked for in the first place, but just like supporting documentation, and
yeah.
then say, well, your application's incomplete, so send us that.
Yeah.
And so the clock hadn't even started ticking. So
Yeah.
the deadline's never been real. It's always just kind of taken as long as it takes, and now it's just even longer because of this shutdown,
Yes.
that is
Well,
put applications on hold for months.
not only a shutdown, but it's also there's been a lot of cuts to the SBA. I think I was watching an interview with Rob Wong and Sam Lee, both who used to work in DC with the SBA. Now they're the private market supporting firms. But they were saying in all of 2025, like only 65 or 66 applications. The main office at the SBA, they went basically down from like 80 people to 40 people. And that's just in the main office, right? So, and then you've got all kinds of offices, the district offices everywhere. So it's really hard to process things when you don't have the people. And I think that catch-all, when practicable, is a good example of how it's not practicable right now for the SBA to, but we've seen this before, Stephen, like you said. I mean, I've seen all the way back in 2010 where it would take sometimes a year or two for a person to actually finally get their application approved.
Yeah, absolutely. And for those who don't know, Sam Lee, by the way, former SBA, longtime former attorney with the SBA, is now in private practice. It's Sam Lee, LE, with just one E and not two. I definitely suggest following him on LinkedIn. He also has a Substack blog as well, because he has a lot of great information about what's going on in that process. But yeah, my understanding is that SBA had a top to bottom like 40% plus staffing cut last year, and that's going to have real impacts, unfortunately, on obviously there are areas where there's duplication. There's people who are sitting there playing Minesweeper and not working, and those things are true, but I doubt it's 40-some% staff. So that just means that there's the services for folks are gonna be affected by that, especially if you then say, okay, of the folks who are remaining, we're moving you off 8A and putting you on SDVSB applications, or whatever the case may be. Which again, as I said before, I think is short-sighted, given that. And I absolutely agree, support the SDVSB program and want those applications to be processed quickly. But keep in mind that I personally have helped a number of veterans and disabled veterans get 8A certification, and that there are hundreds of 8A companies that are veteran-owned right now. And so it's an important program for veterans too, and especially given that with that sole source component, that a lot of those contracts, the veterans can't really get the same contract in the same way under an SDVSB program. So yeah, I think that's kind of where things are now. We've got a short staffing problem at SBA. We've got internal reallocation of resources, and we've got this kind of ongoing pressure from multiple sources on the program, both from inside SBA as well as from, Secretary of Defense or Secretary of War, whatever title you prefer, that's saying we want to audit all these companies. So there's just a lot of pressure right now, that both internally at SBA and externally.
All right. You mentioned Minesweeper. That's an old school.
That's old school. Yeah, I mean, people are probably playing something much cooler now, right? It's like I was, whatever the cool kids are playing, and they're probably just watching TikTok videos or something if they're slacking off at work these days. That's probably what they're doing, just scrolling through it. Hopefully, they're watching our podcast. I mean, that's probably
absolutely, man. Absolutely, it's all the cool kids are doing. So, next question is about how about age discrimination as a social disadvantage criteria? Is that a thing?
Yeah, that can be used as well. I've worked on a couple applications where that was successful over my career. It's not as common as the ones I worked with either a disability or gender, but I have done that, and it's the same thing. It's an objective characteristic. Yep, people can roughly tell someone's age when they meet them, so it's objective, and it's something that has absolutely led to bias and discrimination against many people over the years. In fact, there are federal statutes. Age Discrimination and Employment Act is there for a reason, because age discrimination is real in a lot of cases. So yeah, that is doable. It's a basis of discrimination, and it would just come down to again convincing the SBA that it's easy to convince them what your age is, and it's just okay, here's the ways it had a concrete impact on me. Here are incidents that more likely than not were motivated by discrimination, and that where it stopped me from getting a job or a promotion or a business opportunity or whatever the case may be.
All right. Why are they calling it a DEI program if white people are in the program?
Yeah, I think that there's some misunderstanding about the program. I mean, it really is. I think that this label DEI. I'm not even sure really what that means anymore, but because it's being so broadly used. I think, like I said before, I think there are some people out there kind of who are beating the drum and arguing really, really vociferously, but it's against the version of the program that existed like 5 years ago before this court case took out the presumption. And so there always have been white people in the program. I've helped a number of them get in myself, even under the old rules. But after that court case, after that Ultima case, there's not even the regulatory leg up on the one criteria for minorities anymore. That's gone now. It's still on the books, but it's not enforced. It hasn't been in almost 3 years since that court case came out. So I think that some folks who say, who have the opinion we shouldn't have any sort of preferences in the law for members of certain racial or ethnic groups may look at that regulation and their heads explode and they get really mad and they say it's a DEI program when in fact they may not be aware that the that part of the rule isn't enforced anymore following the court decision, or maybe they are aware they're just trying to score political points. I don't know. But arguing against a version of the program that existed several years ago to me is a waste of time, and it ignores the reality on the ground that even in the era when that preference was on the books, Caucasians could still get admitted to the program. I know I got several of them in. I helped them. I got them in. I mean, I worked on their application with them and helped them with that narrative so that they could get into the program. And so it's always been that
way. Mm-hmm. All right. And we answered this other question, but I'll kind of reiterate it. It was asking, what recommendations for starting a new application, wait until the dust settles or go ahead and apply. And as we mentioned, that would be mostly on a case-by-case basis. And we would recommend that you really think about it strategically from the perspective of, when is the timing right for you? I would say talk to anybody you're working with as a coach, attorney, Apex Accelerator, and just kind of everybody's going to be different and on a case-by-case basis. The other next question is, will SBA have current Hawaiian, Alaskan, etc. with 8A status reapply having to show proof?
No, I don't think they will. And so there's a different track now for, the Ultima case and that idea of the social disadvantage is all based on individual owners, and that's where that racial criteria comes in. The rule for Alaska Natives, Native Hawaiians, and Indian tribes is really a political classification. It's not a racial classification because these tribes are sovereign entities, and so. But they have a different way of qualifying as social disadvantage. For example, Indian tribes, they need to show that, of our tribal membership, here's what our economic situation is. Here's where, we're having unemployment, high rates, and low income, all these sorts of things. They only have to do that once. And so, for example, any tribe that wants to qualify its first company for the 8A program needs to prove that its tribal membership as a whole essentially is disadvantaged. And once they've done that, then they're good to go indefinitely. And maybe at some point SBA could come in and say, show us the data again. But whether they're going to do that seems unlikely to me. And so I think that for tribes, NHOs, ANCs that are already in the program, they're probably fine with their current disadvantaged status. In fact, the Alaska Natives don't even need to show anything. There's a statute that's written by Congress that says they're disadvantaged. Like, we're done. It's not a presumption, but I think it's different than the race base, because it's really a political classification about a sovereign, another sovereign entity, a tribe, something like that.
All right. So I'm going to go through, and we've got about 2 minutes left, but I'm going to go through pretty quickly here, and I'm going to skip over. We've got several, things that looks like more of like their comments and people saying it's how it's like kind of unfair advantage for some of the Super 8As, the Alaska Natives and stuff like that. I don't want to really get into that pretty much discussion because we do have a lot of questions that we want to get to. So, but I would say anytime you think things are not fair, there's always some avenues for that. But we can only really talk about what's actually what is right now on the books. So There is a good question though. If an 8A has an existing sole source contract, it cannot be canceled, correct?
And so, first, just to get back to that, yeah, that's a dispute that people are going to be having until the end of time about, Super 8As, whether it's too powerful and all that stuff. That's a political question. Like those are statutes that are on the books. Don't hate the player, hate the game, sort of thing. Like, don't blame the ANCs for taking advantage of the rules that are written for them. You go to Congress because they put that
Yeah.
program in place. If you don't like it. So, and that's all I really want to say on that, because everyone's going to have a different opinion based on where they come from in that analysis. Yeah, can a sole source? Of course, a sole source contract can get terminated. You default on the contract, the government can terminate you. I mean,
Yeah.
there's no like right to not have a contract
Yeah.
terminated. So they can terminate you for convenience if
Yeah.
they don't want to continue for any valid reason. So yeah, I don't know where that idea came from, but yeah,
Yeah.
sometimes the SBA has to be involved in the conversation about a termination because the contract is technically with the
Hmm.
SBA and the 8A company is a subcontractor, but the government is going to have the power to terminate for default or terminate for convenience,
Right.
ultimately, pretty much as they would with any other contract, potentially with the SBA maybe playing a mediating role if there's an issue there.
Okay. All right. So another question was, again, is there any information regarding new approvals for 2026? I know that Stephen mentioned that as of August last year, there's not been any new approvals. So we're still kind of waiting to see when they're going to kind of get those applications processed again. Um, are there any plans to reinstate the small business or other participatory councils?
Yeah, I don't know anything about that. Unfortunately, I don't have anything. Have you heard anything on that, Carol?
No, I haven't. We have a lot of kind of some of the same questions
Yep.
about, people kind of caught up in the process right now, still waiting. Um, let's see, press releases. Let's see. Okay, press releases around recent suspensions for DC area firms highlighted the total assets of firms, saying that those assets of the business mean that the value of the owner's assets exceeds 6.5 million, but the regulation itself talks about fair market value of the certified company, not the total assets of the certified company when calculating against the $6.5 million total, and the fair market value of an 8A firm could be much lower than the value of its assets because of company liabilities and other factors that go into marketability. Am I missing something?
No, I don't think you are. I don't have any more information than you do, Questioner, but I think you stated that well. That the press release was kind of surprising to me in that regard too, because they talked about it. Almost sounded like the companies themselves were being held to a net worth threshold for the company, which is of course we know is not the case. And then you've got that kind of catch-all uh, rule that says that the owner's net worth at the catch-all level is determined including the value of the company. But ultimately, yeah, I mean, I agree with you. The company's intent should be valued as to what the market will pay for it, and for an 8A company in particular, that can be a really tricky valuation because a lot of the value of a typical 8A company is in the 8A certification, and if you sell that company to somebody who's not disadvantaged, then the 8A goes away. And if you sell it without the SBA's prior permission, it goes away. And so just putting a valuation on an 8A company can be really, really tough. And I think is one of the reasons that historically, at least in my experience, and maybe others have had a different experience, but at least in my experience, SBA has kind of been hands off with using the value of the 8A company as a in the analysis of the catch-all. And I've seen some companies go pretty big in the 8A program, and the SBA did not come in and say that the owner was missing the catch-all threshold for their personal net worth at that point. I think again, given the potential arguments over the valuation of the company and how that would be done. So yeah, we'll see how this goes forward. This is the 154 companies suspended, proposed for termination. There's going to be legal action, undoubtedly, and so we'll see how that plays out because there'll undoubtedly be judges weighing in on what's being done, and if the SBA is somehow got it wrong with respect to how they're calculating the owner's net worth, well, then that's going to be going to be a problem for them when it comes time for these companies to appeal, which I'm sure they're working on right now.
All right. So we've got about 4 minutes left, and I've got one more kind of question. That's a pretty good question. A lot of the questions that remain were kind of along those processing timelines. We've covered those a lot. Also talking about the 8A program fairness and competition and policy reform with regards to ANCs and all of this stuff like that being a part of the 8A program. So we've addressed that. This is a pretty good question, and it's regarding suspension. How does an SBA suspension affect existing 8A contracts, option years, GSA STARS 3 awards, eligibility for new task orders, and upcoming contract extensions, especially if a suspension is later rescinded or caused by a technical issue?
Yeah, and so my understanding is, and I guess I would have to double check this with respect to like something like a GSA, but the SBA suspension rules say you continue performing your existing contracts, you should be eligible for options, orders, etc. It's just the new contracts are not allowed to be awarded. Now, whether there's an exception to that for some of these long-term contracts, I'm not aware of one, but there might be something I'd want to take a look at before giving you a clear answer on that, because it's an important question, really. But generally, the idea is existing contracts, you're fine. Just essentially the same rule would apply if you graduate from the 8A program that day. If you graduate from the 8A program today, could you continue performing that contract? If so, yes. Could you get options on the contract? If so, then you should be fine with the suspension. I think that's really what's intended to mirror, is the process of just like losing your 8A. If you lost the 8A today, could you do it? Then you should be able to do it with a suspension. If you lost the 8A, you can't do it, then probably not, for the most part. I think that's where things are.
All right. Well, Stephen, this has been a really great conversation, a lot of good questions. For those of you guys, if you have some remaining questions, if you've been suspended, or maybe you're an Apex accelerator working with somebody who's facing the suspension, and you're looking for a legal firm to help you out, we've got our partners' information here at GoPrince McCall Potroff LLC. Great firm, and I know that they'd be open to having an initial consult with you. By the way, how does that work, Stephen, in terms of when you're reaching out to a law firm for questions?
Yeah, I mean, it's going to depend on the individual law firm as to how they want to handle that, and so I can't speak for how Shane and Nicole are handling their consultations these days. When it was me, I would offered an introductory call of up to 30 minutes. It was really intended to be a get to know you thing. It wasn't a legal advice type thing, but just to make sure it was the right fit. And if so, then we would move forward with an engagement from there. But they may be doing things differently, and other firms may do things differently. So it's just going to depend. Some firms don't offer free consultations. Some do.
Yeah.
Some will provide you full legal advice in that setting, but a lot are not going to do that. Like I said, my purpose in the consultation was a getting to know you type thing, making sure it was a good fit, and then we move on from there, rather than an opportunity for someone to quote unquote pick my brain for half an hour for free and then disappear. Like, that's not. I mean, I'm in business too at that point. So that makes sense.
Well, I always tell folks, and I mean, I repeat this time and time again, that if you're going to be in a government contractor and be sustaining yourself and growing at some point, it's going to really be into your advantage to have a good legal firm that specializes in GovCon. The team at GoPrince McCall Potroff are a great team, and I know that there's a lot of other attorneys out there. So if you guys are really having issues with suspensions or anything else like that, in terms of all of the questions that came in with like, hey, you're kind of like stuck in the application process, you're not getting any response, I would just tell you, be patient. We kind of believe we have a philosophy that we believe all things that happens for a reason. So maybe it being delayed is going to, save you some time into the program as things get a little bit more organized and settled in, because personally, I wouldn't want to go in right now, considering, until I would see that the sole source advantage may be lifted. But again, as we mentioned, that's all going to be on a case by case basis. So, reach out to whoever your support network is, an Apex Accelerator, your consultants, your attorneys that are out there. And yeah, I think that's all I've got on that. Stephen, you got any last words as we exit here today?
Yeah, it's just, I mean, it's a shame there's so many folks who are stuck in that situation. I wish that I had the magic, oh, do this, say this, and it'll all be good. But unfortunately, we don't. You and I and everybody are just kind of waiting to see what happens at SBA. Obviously, if as soon as I have any information that things are moving again, or if there any more news on that sort of front about what folks should do if their application is stuck in the system, I'll post that on my LinkedIn and probably on my blog over at the fedlift.substack.com as well, so to keep people updated. But unfortunately, I don't have the magic bullet. Just yeah, I mean we're all in this together now, and just kind of stay the course. And as soon as I have some information, I'll let folks know about it.
All right, awesome. Well, hey, thank you everyone for joining us. And again, if you are a member of our Govology community, you'll see updates on when we're going to be posting our next episode of GovCon Roundup Live. We typically do these on the third Wednesday of every month. We also have the show posted typically around the first of each month there at govology.com/roundup if you want to check it out. But we also will send an email out for you guys. And if you are not already on our distribution list and you want to get on, just send us an email at support@govology.com. And with that, this wraps up our topic of the day. Thanks again, Stephen. And we look forward to seeing everybody next month.